Hi everyone, welcome to our channel. Today our topic is Contract Labor Regulation and Abolition Act 1970. Let me give you a brief idea of what actually is this law rather than going directly into that law. Just a brief introduction so that you understand it in a better way. See, there is a company, there is an owner called as a principal employer. He doesn't get the laborers directly. So what he will do, he will appoint a contractor. So contractor is a person who is in between and he will get the laborers for a contract. So this is the basic basic idea about this. And where there were some problems faced by the workers. They were not getting wages, they were not getting some proper facilities from the contractor. So this law, to solve all the problems that are there related to contract laborers and contractor, so this law has come into picture. So this is the reason why the law has come. Now we got a practical idea that there is a principal employer, a contractor and a workman. So there were some problems and so this act has come into picture. Okay, now let's see where it is applicable and in detail we'll talk about this act. The very first slide talks about the application. It is applicable to every establishment in which there are 20 or more workmen who are employed for any day of the preceding 12 months as contract. So this points, see, it is applicable for any establishment having 20 or more workmen. What if you might be having a question, what if the establishment is not having 20 members? Then what? It is not applicable? It is applicable where the appropriate government comes into picture. They will give you a notice for 2 months, then that is applicable. You can also note a point on this. Please maintain a notes of your own handwritten notes so that it will help you in revision. Okay, now you understood this is applicable to an establishment where there are 20 or more workmen who has joined the company in any of the day preceding 12 months as contract. Now we'll discuss where it is not applicable. It is not applicable in an establishment in which the work only of intermittent or a casual nature. You should remember this keyword intermittent. The word intermittent is something has a meaning of irregular or not continuous in process. So it is not applicable in that industry, in that particular establishment. So it is not applicable where it is intermittent or a casual in nature. Where it does not include, it shall not be deemed of an intermittent nature if it has performed more than 120 days in preceding 12 months. If in case of seasonal characters, it should not be more than 60 days in a year. This is the condition. Intermittent is not regular. So it is not performed for more than 120 days and 12 months, and if in seasonal characters for not more than 60 days. These are the points you have to remember. Please understand and write it on your own. So applicable if there is an establishment of 20 or more members. Not applicable if it is in the nature of intermittent. So it is not applicable where if it is have done for more than 120 days in 12 months and seasonal characters in 60 days in a year. Okay, coming to the definitions. You have to pay more concentration or pay your attention towards this definition very clearly. Just don't say that I know who is a contractor, I know what is an establishment. When there is a question, you will understand. So who is a contractor? A contractor is a person who undertakes to produce a given result. So he produces the given result. The principal employee, the owner will give him, so this is the task I wanted to complete. So contractor will produce that result for that establishment. He will not include a mere supply of goods or articles of the manufacturer. Okay, manufacturer for that establishment. So what is included? He will only produce what is the given result. He will not be included in the mere supply of goods and articles or manufacturing of such establishments. It includes the subcontractor. There was a question in UGC NET saying which of the following does not fall under the definition of contractor. I'll give you options. See, a person who produces a given result was the first option. The second option, he includes himself in supply of articles and manufacturing establishment. Third one, it includes the subcontractor. Now you know that he does not include in the mere supply of goods or articles of the manufacturer. He is only there to produce a given result, and it includes the subcontractor. Okay, done. Good. Establishment means any office or a department of a government, any local authority. It can be any place of an industry or a trade, business, manufacturer, or an occupation where it is carried on. It can be anything. It can be a department, it can be an office, it can be a place where the business is carried on, it can be a manufacturer or an occupation. Okay, that is an establishment. Now we'll talk about the principal employer. Who is the principal employer? I have been from starting saying the principal employer word, right? He is the head of the office or a department. He can be the owner, he can be the occupier, a manager, and whoever, if I have to speak who is the principal employer. Principal is something that important, right? There are the heads of a school. Principal is the head of the school. Same way, the principal employer is a person who takes the supervision, who takes the control of that establishment, is called as a principal employer. It includes head of the office or department, an owner, officer, manufacturer of a factory, any person who is under the supervision and control of the establishment. Okay. Who is a workman? A workman is a person who works, right? But it does not include a person who is at the managerial level. First thing, he is not involved in the administration, and he does not even draw a amount which is excess of 500 rupees, and who is not a outworker. Who is an outworker? Like, it does not include them in the workers. Worker is a man who takes less than 500, who is not involved in manufacturing and administrative processes, and whoever is an outworker, he will not be included in that particular workman. Understood? Simple. Okay. Advisory boards. There are two advisory boards. The reason I have differentiated them in a slide, because you will understand the difference and it would be easy. If you're studying in a separate way, it will be made difficult, or you might forget, right? So let us compare and study the two advisory boards that we have, the Central Advisory Board and the State Advisory Board. The central is appointed by the central government. The state is appointed by the state government. A chairman appointed by the central government. A chairman is appointed by the central government, and the chairman is appointed by the state government in the State Advisory Board. So here the main point. In the Central Advisory Board, the chief labor commission is the ex officio. So central will have the chief, whereas the state will have only the labor commission as the ex officio. Clear with this point? Okay. The number of members shall not exceed 17 but not less than 11. So the range of people in the Central Advisory Board is 11 to 17. This is very, very important question that has been asked. You have to remember this. And in state, it should not exceed 9 to 11. So the thing is 11 to 17 in Central Board, state 9 to 11. Okay. Please make note of this point. It is very, very important, and you have to revise it so that you don't forget. Coming to the registering offices. See, why do you need a registering officer? You have to register your establishment, right? So in order to register your establishment, there has to be some person called as a registering officer. Who appoints him? The appropriate government appoints him. What is an appropriate government? It can be a central government or a state government. Coming to central government, the central government involves railways, oil and ports, mines, the major parts like oil and mines and the railways comes under the central, remaining all other comes under the state government. So appropriate government will appoint a registering officer. So when you hear about this registering officer, the very first thing that you have to get into your mind is the principal employer. So when there is a registering officer, every principal employer of an establishment shall make an application to the registering officer for the registration. So principal employer will apply for an application for the registration. So the registration is, if it is everything is in a proper way, they will get a certificate of registration. If not, there is some misrepresentation, the false representation that has taken place, then the registering officer will have all rights to revoke, that is, stop this registration. So registration officer is a person who is appointed by this appropriate government. Every principal employer of an establishment will make an application to the registering officer for the registration. So if everything is in a proper way, you get a certificate of registration. If it is not in a proper way, there is some mistakes, there is some misrepresentation, there would be some revoke. The registering officer will have all rights to stop if there is something wrong in your application. Okay, coming to the next, licensing officer. In anything, the registering officer or the licensing officer are appointed by the appropriate government. This is the basic thing. Anybody, registering officer, the licensing officer are appointed by the appropriate government. Okay, what does this licensing contains, or what happens in this licensing? You apply for that registration, right? They have all the rights, the licensing officer will have all rights to investigate on your application. He has powers to revoke the license as well. And in this license will have the location of an establishment, the nature of the process, operation of the work. So it is where the location is present, what kind of work process or operation that is taken by the labor is understood by this licensing officer, and he has all powers to cancel your license as well if something goes wrong and you're not doing in a proper way or in such kind. And this license is applicable for only 12 months. Okay, after 12 months you have to apply again for this license. Okay, any person who is not aggrieved and something happens and you are not agreed with the licensing officer, you say everything is right, then you can appeal to the next level, that is appellant officer, within 30 days. Within how many days? Within 30 days, that is 1 month of that date of order. If you did not get your license, the licensing officer had some issue, or he said this is not there, that is not there, but you feel everything is correct from your end, so the person will go for the appellant authority or an appellant officer within 30 days. Once the licensing officer are rejected, within that 30 days of period, you can appeal to the appellant officer. Okay, simple. You studied about the registering officer, licensing officer, and remember this, 30 days, within 30 days, if you are not happy with that, you can go appeal to the higher authority. Coming to the welfare and health of the labor. See, you are contracting the laborers, and it is your duty to provide some kind of facilities for that contract laborers, right? So it is the duty of whom? It is the duty of the every contractor, because he is the person who is employing or taking the people into his contract, right? Into his labor work, right? So he has all the duty and rights to provide them some facilities. What are the facilities included? It is the basic things: drinking water, latrines and urinals, washing facilities, canteen. If there are people who are employed for more than 100, then canteen is for 100 people. Remember this point, 100, this has been asked. Okay, first aid, if there is some accident or some necessary immediate treatments, first aid, and they should be provided with the restrooms. So these are included in the facilities. You had a question in UGC net saying which of the following is not one of the facilities that is provided for the contract labor. You have to choose from them, right? So you have to remember these points, drinking water, basic things, latrines, washing facilities has to be given. If there are 100 and more people, you have to give them canteen. Restrooms is important. The first aid box is necessary, right? Okay, moving on to the next. Who is responsible for paying the wages to the laborers within a time? The contractor, because he's the person who gets the contract laborers. So contractor will pay them. If there is some shortfall in the payment, or he's not paying on right time, if the contractor fails, then it is the principal employer is liable to pay the payments of wages. Okay, simple. Contractor will pay the wages in the right time. If he is unable to pay the wages, the principal employer will pay. He is liable to pay. Okay, coming to the penalties. See, simple way I can say you that you have to remember is a small logic. Remember, you have this contract for 3 months. So everything, the imprisonment will come for 3 months. Okay, the contract is for 3 months. Just remember in this way, contract is for 3 months. So wherever you see the penalty or some imprisonment, fine, then you will have this 3 months. Okay, it is common. So now let's see what are the penalties. Whoever obstructs or refuses an inspector in the discharge of duties. So whoever stops the inspector on doing his duties, then he will be prisoned for 3 months, as I said, and he will have a fine of rupees 500. Okay, next, if there is a contravention of a provisions regarding the employment of the contract labor, then again the imprisonment is for up to 3 months and fine of rupees 1000 rupees or both. If the contravention is continued, then the fine will be rupees 100 for every day. So each day you're going to pay 100 rupees extra. Remember this 100 as well. Okay. Any other offense, if there is any other offense, again you have the imprisonment for 3 months and fine up to 1000 rupees. So the common thing is 3 months and 1000 rupees. Only when the inspector is refused, then you will pay 3 months and 500 or both. Okay, simple na? Right. Coming to the next one, limitations. Limitations of the prosecution. No court shall take the cognizance of the offence unless a complaint. See, nobody will get interfered. No court has right to interfere in this complaint unless there is a complaint made within 3 months from the date of which the aligned commission of the offence come to know the knowledge of the inspector. See, within 3 months you can do. If there is a complaint within 3 months, then the court can take the action. Without any notice, without any complaint, no court has right to get into their affairs. Okay, if there is a offense consists of disobeying a written order made by the inspector has said something and there is an offense of disobeying him, then the complaint can be made within 6 months. Understood? Two things. If there is any complaint, then within 3 months the court can get into an affair of this incident. And if there is something disobeying, the word disobeying comes, then you have to go with 6 months. Right? Simple. Coming to the registers and other records. In this, every principal employer, every contractor shall maintain the registers and records. It is simple. The two main bodies, the important bodies, the principal employer and the contractor, shall maintain the registers and the records. What is there in that records and registers? The nature of work performed by the contract laborers. What is the rate of wage that is paid to the contract laborers? Two things. Okay, the nature of work, what kind of work that has been performed, what wage has been paid. This is registered in the records. Okay, who will maintain them? The principal employer and the contractor. Now let's understand the knowledge test, because we understood, and if at all I haven't covered anything, you will see in this questions. Okay, there are only 2 questions. Okay, the term wage under the contract labor has same meaning under which legislation? See, if you find any question of such kind, wage of same meaning, it will be wage is always related to the Payment Wages Act 1936. Okay, the answer is Payment Wages Act 1936. Let's see the next question. As per Contract Labor, the Regulation and Abolition Act 1970, the minimum number of the contract laborers needed to provide a canteen. We talked about canteen, right? It was how many people? How many people has to be employed? At least if they are more than 100, for sure there must be a canteen. So for 100 employers, you have to provide a canteen. Okay, now this has come to an end. You have understood what actually this law deals with. Simple, just a quick revision, just a rewind of it. It is applicable for 20 or more workmen. If they are not less than 20, then the government has to give a notification within 2 months. Remember, 22 months. Okay, not applicable where it is an intermittent in nature. It is not included if it is performed for more than 120 days and 12 months. Seasonal characters 60 days. Seasonal 60 days and more than 120 in 12 months. Okay, coming contract. Contract is A contractor. Who is a contractor? A person who understands or undertakes whatever the result is to be produced. And next is, he will not supply the goods and manufacturing part, and it also includes the subcontractor. Coming to the establishment, it can be any office, any place. Okay, principal employer, he is the head of the department, he is the owner, occupier, manager, whoever is at the supervisory level, and whoever controls the establishment. Workman, he will not include any supervisor or managerial or an administrative capacity. He will not draw the amount exceeded more than 500. And who is an outman, he is not included in this workman. Advisory board, that is central and state, we have differentiated. So here the important point is, chief election commissioner under the central government will be the ex officio, and in the state only the labor commissioner, right? And you have to remember the limits, that is 11 to 17 people. It will be not less than 11, but not more than 17. Okay, when coming to state, it is 9 to 11. The minimum is 9 and maximum is 11. Okay, registering officer, we talk, who appoints, the appropriate government appoints, right? If there is any misrepresentation, he has all rights to revoke or stop. So who will apply for the application of registration? The principal employer. Okay, coming to the licensing officer, he is appointed by the appropriate government. It will contain the location of establishment, the nature of works, the process of the work that is done. Okay, he also has the power to revoke, that is cancel your license. The license has to be taken every year. It will be valid only for 12 months. Every year you have to. If you are not agreed with the licensing officer, you can go to the appellant officer within 30 days. Okay, next, welfare, you have to take care, the contractor has to take care of the facilities like drinking water, latrines, washing facilities, canteens, the first aid box, and the restrooms. Contractor has to pay the wages. If the contractor is unable to pay or he fails to pay, then it is a responsibility of the principal employer to pay the. Coming to penalties, I said, just remember the contract is for 3 months, so imprisonment is also for 3 months in everything. If it is the discharge of refuse of an inspector, it would be from 500 and 3 months. And if in any other case, it will be rupees 1000 and 3 months. And this is the way you remember, everything is like a theoretical way. Only when you link and study, that is the way you make things easier, right? Coming to the limitations, if there is a complaint of within 3 months, then the court can get into things. If there is no complaint, then there is no court can come into the interference of this particular thing. And if there is some disobeying kind of thing, then within 6 months they can go for it. This, coming to the registers, it has to be maintained by the principal employer and a contractor. And we talked about the knowledge test. I hope you understood. If not, please revise it again, make your own notes, and please revise it so that you get aware of this more and more. And it will be easy when you read other laws. At a time you're reading all the laws, it will create a big mess or a big confusion in yourself. So I suggest that read this, revise it twice or thrice, write it on your own, whatever the points you understood, and the things will make easier and you become perfect in labor law. Okay, and I wish you all understood everything. And if suppose you wanted some other topic of labor law which you feel difficult, please comment below so that I can make a video and it will be helpful for you. And a big thank you. If you like this video, please like and subscribe for more videos, and that gives me a big motivation to make other videos. Thank you so much. Bye bye.